Antitrust law and ancient history. Antitrust law is an aspect of a larger field called competition law. Competition law tries to ensure that markets are fair and competitive. American law tries to ensure that American markets are fair and competitive, primarily through our antitrust laws, which we'll discuss in detail in this video series, and also through American consumer protection law, which is a story for another day. The Federal Trade Commission, the FTC, has both a Bureau of Competition, which handles antitrust concerns, and a Bureau of Consumer Protection, which deals with deceptive trade practices, like telemarketing fraud. Competition law has an ancient history, beyond what I could comprehensively present right now, but I do want to give you a sense of how antitrust law today fits into our ancient legal history. Ancient Jewish law established morals of the marketplace, and Jewish law set up courts to enforce violations of marketplace norms as long ago as perhaps 1150 BCE. History records these ancient courts in Deuteronomy 16:18 and elaborates them in the book of Judges. The Roman Republic established laws protecting their grain trade in 50 CE. In 301 CE, Emperor Diocletian established the death penalty for anyone who created a black market for illegally sold goods. Arabic law prohibited the charging of interest, called riba, probably in the pre-Islamic era, and then the Prophet Muhammad prohibited riba via the Quran, which was published in 1610 to 632 CE. The Quran prevents riba in several sections, including 275 to 280. And after the Norman conquest of England in 1066 CE, for example, King Henry III established the Assize of Bread and Ale Act to fix the price of bread and ale. Such price fixing, we will soon see, is precisely the opposite approach that modern antitrust law would take, using the markets to set prices, although both seem to share the goal of keeping food prices affordable. Back on the continent, in Europe, merchants were establishing guilds that resemble early forms of trade associations. Guilds are early forms of unions that collectively lobby governments, perhaps monarchs in those days, for exclusive permission to ply certain trades. Guild members enjoyed the exclusive privilege of selling some type of good within the city walls. We know that guild-like associations date all the way back to ancient Sumaria, Assyria, because the Code of Hammurabi reflects concepts related to guilds. The interesting thing about this ancient history of competition law is that it changed recently. Much of the law had focused on protecting competitors from competition. Guild members, for example, were protected from competition from non-guild members. Non-guild members were not allowed to sell the same goods within the city walls. Competition law has shifted its goals, now protecting competition instead of protecting competitors in the late 19th and early 20th century, based on a neoclassical understanding of how the economy works, particularly after Bork's 1978 Antitrust Paradox book. Next, we'll take a look at some of the fundamental economic concepts in neoclassical economics, because antitrust law makes more sense when we realize what it's trying to accomplish through the lens of relatively modern economic theory.